The memo ICE kept secret, and the senator who found it. A 10-year-old girl watched federal agents break down her front door. Her name is not in the hearing record. Her father's name is Garrison Gibson, Minneapolis. ICE's agents arrived at his home with a document signed not by a judge, but by another ICE agent. A supervisory detention officer authorizing himself and his colleagues to enter, detain, and arrest. The door came down. Gibson was taken in front of his wife, Tiana, and the 2 children in the house. One of them was 10 years old. The other was a niece who happened to be there. Senator Richard Blumenthal held up a copy of that document in the hearing room. He held it the way someone holds evidence they have been waiting to present in the right room, at the right moment, in front of the right person. Not dramatically. Not for effect. With the deliberate calm of someone who understood that what was in his hand was more powerful than anything he could say about it. He let the room see it first, let the people in the gallery and behind the committee dais absorb what they were looking at before he named it. Then he called it a permission slip. The ICE director, seated at the witness table, did not dispute the description. He couldn't, because what Blumenthal was holding, the I-205 administrative warrant, is not a judicial document. It is not signed by a judge. It does not require a finding of probable cause by an independent officer of the court. It is a form signed by one ICE agent authorizing other ICE agents to do what the Fourth Amendment of the Constitution requires a judge to authorize. That is the hearing. That is the document. That is the legal question that the next hour of testimony could not resolve. Let's go back to the memo first, because the Garrison Gibson case did not happen in isolation. It happened pursuant to a policy, a written policy, one that authorized ICE agents to conduct home entries on the basis of administrative warrants rather than judicial ones. A policy that existed in a memo that was never announced publicly, never released to the press, never made available to the American people or to Congress until 2 whistleblowers walked it into the committee's offices and said, this is what they're operating under. Blumenthal put that on the table before anything else. Not the cases, not the photographs, the memo, the internal document that explained the cases, the policy that produced the photographs, the administrative authorization that connected a secret internal directive to a broken door in Minneapolis. He had learned about it from 2 people who came to the committee because they believed what they were describing was wrong enough to require the risk of coming forward. Whistleblowers. The word carries weight in a hearing room. It signals that the information being discussed was not offered voluntarily by the institution that generated it. It signals that someone inside the institution decided that the public interest outweighed the professional risk of disclosure. 2 people had made that decision. They brought the memo to Congress, and the director was now being asked to explain why that was necessary. He asked the director directly, why did you keep this memo secret? The director said he didn't keep it secret. He said it was sent to the ICE workforce by email. 30,000 people. He said if sending an email to 30,000 employees is keeping something secret, it's a bad secret. Blumenthal looked at him. He said it never reached the American people. It was never announced. The press never reported on it because no one gave it to the press. Congress learned about it from whistleblowers, not from the agency, not from a press release, not from a briefing, from 2 employees who came forward because they believed the policy was being used as the basis for enforcement actions that violated the law. The director didn't have an answer for that, not a substantive one. He offered to coordinate with the committee to get the relevant materials, a phrase that means future compliance rather than present accountability. He had an answer for the mechanism of distribution. 30,000 employees, email, sent. He did not have an answer for the gap between internal distribution and public disclosure, between an agency knowing its own policy and the people subject to that policy knowing it exists. Between the 30,000 ICE employees who received the memo and the tens of millions of people living in communities where ICE agents would now be authorized to enter homes on the basis of a form signed by another agent rather than a warrant signed by a judge. He said the email went to 30,000 people as if that answered the question of why it didn't go to the 30 million people affected by the policy it described. The memo is real. The policy is real. The Garrison Gibson case is real. And the connection between them, the chain from a secret internal directive to a federal agent signing his own warrant to a broken door in Minneapolis, is what Blumenthal had come to document. The agency knew. It just didn't tell anyone outside the agency. A policy authorizing warrantless home entry sent to 30,000 employees. Not one press release. This channel tracks the documentation as it moves through the legal system. If you want to follow where this goes, subscribe and turn on notifications. New videos drop when the record produces something worth documenting. Now let's talk about the Fourth Amendment. Blumenthal started there deliberately, not with the cases, not with the victims, with the constitutional text, the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The requirement that warrants be issued only upon probable cause supported by oath or affirmation, and particularly describing the place to be searched. He established the baseline first. If you are the FBI and you want to enter someone's home, you need a judicial warrant. A federal judge reviews the evidence, makes a finding of probable cause, signs a document that authorizes the entry. That document is the product of an independent judicial officer applying a constitutional standard. If you are a local police officer and you want to enter someone's home, the same standard applies. A judge, probable cause, a judicial warrant. ICE agents are doing the same thing. Entering homes, detaining people, making arrests without that warrant, without the judge, without the independent finding. On the basis of a document signed by another ICE agent, Blumenthal asked the director, what is so different about ICE that it regards itself as an exception to the Fourth Amendment? The director cited a case, U.S. versus Lucas, 2007, out of the Eighth Circuit in Minnesota. He said that case authorizes home entry to catch a fugitive based on an administrative warrant. Blumenthal was prepared for this. He said the case does not abrogate the Fourth Amendment. It is one circuit court decision from 2007 in one district. It is not a Supreme Court ruling. It is not a constitutional amendment. It does not say ICE agents can bash down doors and barge into people's homes and terrorize children and detain people without a judicial warrant. It says something narrower, applied to a specific set of facts in a specific legal context. Citing it as blanket authorization for nationwide administrative warrant-based home entries goes further than the case holds. There is nothing different about what ICE does compared to what the FBI does or what local police do that would justify the exception. The FBI enters homes. Local police enter homes. Both require judicial warrants. Both require judges to find probable cause. Both require the constitutional standard to be met before the door opens. ICE enters homes. ICE does not require a judicial warrant. The agency has decided that its function is constitutionally distinct from every other law enforcement function in the country in a way that exempts it from the founding document's most fundamental protection of the home. The Constitution does not have an ICE carve-out. The Fourth Amendment does not ask which agency is conducting the search. It asks whether a judge authorized it. The director held his ground on the case law. Blumenthal held his ground on the Constitution. And between those two positions, the agency's legal interpretation and the constitutional text, sat Garrison Gibson's family in a Minneapolis home where the door had been broken down by agents operating on a form signed by another agent. That is not an abstraction. That is a fact. Blumenthal put the photograph on the table, not a diagram, not a legal brief, not a case summary or a statistical analysis of administrative warrant usage. A photograph, the kind that cannot be disputed on procedural grounds or characterized as speculation or dismissed as anecdotal. A photograph of ICE agents at the door of a specific home in Minneapolis on a specific day. The visual record of what the administrative warrant policy looks like at the moment it becomes a physical act. The moment before the door came down, the moment that the memo's language, which described authorization standards and enforcement procedures and administrative classifications, became something experienced by a 10-year-old girl in a house in Minneapolis. Blumenthal held it up so the room could see it before he spoke about it. He gave the photograph the weight it had earned by being real. The director looked at it. His posture at the witness table did not change. He had been sitting with the particular stillness of someone who understands that every answer is being recorded and has decided that measured, controlled, process-oriented responses are the strategy. He had been through hearings before. He understood the format. Question, answer, deflect to procedure, maintain composure. His hands were flat on the table in front of him. He did not reach for papers or look away from the senator. He maintained the controlled attentiveness of someone who has calculated that the appearance of engagement is itself a form of defense. That looking responsive, while not being responsive, is sustainable if the performance of it is consistent enough. Blumenthal was not accepting the performance as a substitute for the substance. Blumenthal was not asking process questions. He was asking constitutional ones. And the difference between those two categories of question is the difference between a hearing that produces administrative commitments and a hearing that produces a record of whether the agency believes the Constitution applies to it. This hearing was producing the second kind. Here's what the administrative warrant argument actually means in practice. A judicial warrant requires an independent check, a judge, not the agency doing the searching, reviews the evidence, finds probable cause, and authorizes entry. That independence is the constitutional point. The Fourth Amendment was written specifically to prevent the executive branch from authorizing its own searches. When an administrative warrant is used instead, that check disappears. One ICE agent reviews the evidence, signs the form, hands it to another agent. The door comes down. No judge, no independent review, no constitutional filter between the agency's desire to enter and the actual entry. The family on the other side of that door cannot challenge it before entry because there is no judge to challenge it to. They can only experience the consequences and seek legal remedy afterward. ICE has removed the constitutional step that exists to prevent that sequence. Garrison Gibson experienced the consequences. His wife and children experienced the consequences. And the administrative warrant that authorized those consequences was a form signed by a supervisory detention officer, not reviewed by any court, not subject to any independent check, not required to meet the constitutional standard that applies to every other law enforcement agency in the country. Blumenthal called it a permission slip. He was precise. A permission slip is what one person gives another person to do something that requires authorization. It is not a judicial determination. It is not a constitutional document. It is an internal form. And the policy that authorized ICE agents to use internal forms as a substitute for judicial warrants was the policy in the memo that 2 whistleblowers brought to Congress because the agency never announced it publicly. Now let's talk about the 22 Americans. One broken door made national news. The committee had documented 21 more because the Garrison Gibson case was one incident, one family, one photograph, one document on the hearing table. The committee had documented 22, not one case, not 2. 22 documented U.S. citizens detained, assaulted by immigration agents. 22 United States citizens detained and assaulted by immigration agents. That number came from a report prepared by the ranking member's staff. It had a title, Unchecked Authority. It documented not just the detentions, but the written statements from 8 of those citizens. People who described being detained, shot at, nearly killed, by agents who came looking for someone else, or who made a mistake, or who acted on information that turned out to be wrong. Blumenthal introduced the report into the record. He moved through the cases with the specific pace of someone who has decided that the accumulation of documented facts is more powerful than any single argument. George Reeds, Army veteran, father, California. Trying to go to work, he said he was tear-gassed. Held for 3 days. No charges. Blumenthal asked the director, is he lying? The director said ICE wasn't involved in that arrest. Blumenthal didn't move off it. He noted that the director had stated in prior testimony on Tuesday that no U.S. citizen is subject to immigration enforcement. He cited the exact quote. He held it against the documented cases. He asked, were you mistaken? The director said no. He said he was speaking about immigration enforcement specifically, enforcement that results in deportation or removal. He said that if a citizen is detained in the course of an immigration investigation, they are quickly released. Blumenthal produced the next case, Alaya Rahman, disabled woman, Minneapolis. She came to the hearing. She testified before the Spotlight Forum. She described being violently dragged from her car, detained without medical attention until she passed out. He asked, is she lying? The director said no, she's not lying. Then Blumenthal made the logical connection explicit. If she is not lying, and the director had just confirmed she was not, then the director's statement that no U.S. citizen is subject to immigration enforcement was incorrect. A disabled U.S. citizen was dragged from her car and detained without medical attention until she lost consciousness. That is, immigration enforcement applied to a U.S. citizen. The statement and the documented reality cannot both be true. The director tried to draw a distinction between enforcement that results in deportation and enforcement that results in temporary detention. He said the term enforcement was being used in a specific legal sense. She passed out. That is not a specific legal term. That is a description of what happened to a U.S. citizen in federal custody. Blumenthal said that was a circular argument. She wasn't subject to immigration law because she is a U.S. citizen. But she was detained by immigration agents, and she was not quickly released. She passed out first. The distinction the director was offering required the word enforcement to mean something so narrow that it excluded the documented experience of the person sitting in the hearing room who had experienced it. Then came Miramar Martinez, shot 7 times by CPP agents, and Diana Figueroa, dragged from her car after dropping her son at school, thrown into a van, detained. For each case, Blumenthal asked the same question. Is she lying? For each case, the director confirmed she was not. And for each confirmation, the prior statement, no U.S. citizen is subject to immigration enforcement, became more impossible to defend. That sequence was not accidental. Blumenthal had built it deliberately, not to humiliate the director, not to score a political point, to create a record, a documented, case-by-case, on-camera record of the gap between the official statement and the documented reality. Each case was a data point. Each confirmation, she is not lying, was a narrowing of the space in which the prior statement could survive. By the time he had gone through 3 cases and received 3 confirmations that the documented accounts were accurate, the prior statement had been rendered indefensible without the director having acknowledged that it was. That is a specific kind of hearing room work. It requires patience and preparation. It requires knowing the cases well enough to present them in sequence. It requires resisting the impulse to press for the concession too early before the record is fully established. Blumenthal let the record build case by case. He did not demand a retraction after the first one. He let the weight of the accumulation do the work, a record that does not close when the hearing ends, that lives in the transcript. That will be cited in every subsequent legal proceeding, every congressional inquiry, every civil rights lawsuit that builds on what was documented in that room. Who's lying? You or him? That question. The 4 words that stopped the hearing room came from the George Reed's exchange. The room understood when Blumenthal framed it that way that the question was not rhetorical. It was a binary, a genuine forced choice between 2 options, each of which carried consequences for the person on the receiving end. If George Reed's was lying, that was a claim about a named individual with a documented account. If the director was lying, or wrong, or mistaken, or had made a statement that was not accurate, that was a claim about official sworn testimony. Both possibilities were serious. The question forced the room to hold both of them simultaneously. Blumenthal had established the prior statement. No U.S. citizen is subject to immigration enforcement. He had produced the documented case. An Army veteran. Tear gas. 3 days. No charges. He had confirmed that the director acknowledged the policy statement. He had produced George Reed's account. And then he asked, the facts contradict what you said. Will you admit that? The director said ICE wasn't involved in that arrest. Blumenthal rephrased it as a direct binary, you or him. One of them is wrong. One of them said something that is not true. The director said he was speaking for the men and women of ICE in his operation. He said he didn't arrest that individual. That answer is worth examining because it does not address the question. The question was not who specifically made the arrest. The question was whether the prior statement, no U.S. citizen is subject to immigration enforcement, was accurate, given the documented evidence of U.S. citizens being detained, shot at, dragged from cars, and held without charges. An institutional statement about an institutional policy was being tested against documented individual cases. The director responded by distancing himself from the specific cases rather than accounting for the gap between the policy statement and the documented reality. Blumenthal noted this. He said, the facts contradict what you said. The director said, to say that we're lying is a correction. That exchange, the resistance to the word lying, the offer of correction as an alternative, is itself part of the record. Because the alternative to lying is being wrong. And the director was not conceding that he was wrong. He was offering correction as a softer frame for an inaccuracy he would not name as such. The distinction between lying and being wrong matters legally. It matters institutionally, but it does not change the documented fact that an official statement was made, that the statement described a policy that was not accurate as applied to documented cases, and that when those cases were presented, the director chose to defend the statement rather than account for its inaccuracy. The word correction was offered, not the correction itself, not a revised statement, not an acknowledgement that the prior testimony needed to be updated, just the word as a softer frame for an inaccuracy the director would not name as such. The record does not accept softer frames. It accepts transcripts, the administrative warrant, the Fourth Amendment, the memo, the 22 citizens, the specific documented cases, the prior statement, the direct question. All of it is in the record now. Here is what the hearing established that the agency's press office cannot revise. The memo exists. Its contents authorize administrative warrant-based home entries. It was never publicly announced. Congress learned about it from whistleblowers. The director's characterization of this as routine internal communication is now in the record next to the whistleblower's characterization of it as a secret policy being used to conduct entries that the Fourth Amendment requires. A judge to authorize the administrative warrant is not a judicial warrant. The director confirmed this. The I-205 is signed by a supervisory detention officer. It is not reviewed by a judge. It does not require a judicial finding of probable cause. The legal argument the director offered U.S. v. Lucas, 2007, is in the record next to Blumenthal's constitutional counterargument. A court will eventually resolve that dispute. What the hearing did was put both positions in the permanent record simultaneously. The 22 citizens are documented. Their cases are in the report. 8 of them provided written statements. 3 of them were named in the hearing. All 3 were confirmed by the director to be telling the truth. All 3 documented experiences that directly contradict the prior statement that no U.S. citizen is subject to immigration enforcement. That contradiction is now in the permanent record. 3 confirmed accounts, 3 direct contradictions, 1 prior statement. All of it documented, time-stamped, and in the Congressional Archive. And the prior statement is in the record too. The exact quote, the exact date, the exact context, the word enforcement, the director's explanation of what that word meant, and the documented cases that the explanation cannot account for. The hearing did not resolve the constitutional question. That question, whether the Fourth Amendment permits administrative warrant-based home entries by ICE agents, will be resolved in courts through litigation over years of legal proceedings that will reference this hearing and the documentation it produced. What the hearing did was fix the record. It took what had been a policy question and internal agency practice described in a memo sent to 30,000 employees and made it a constitutional one, documented in the congressional record, attached to specific cases, specific names, specific documented harms, and the specific gap between official statements and documented reality. That gap does not close when the hearing ends. The 10-year-old girl who watched the door come down is still 10 years old. The administrative warrant that authorized the entry is still in federal files. The memo that authorized the policy is still in federal files. The prior statement is still in the congressional record. And the cases Garrison Gibson, George Reeds, Elia Rahman, Miramar Martinez, Diana Figueroa are still documented, still attached to real people, still part of a report that is now part of the permanent congressional record. The follow-up matters. The constitutional question raised in this hearing will be adjudicated. The gap between the official statement and the documented cases will produce litigation. The memo will be cited in court filings by attorneys representing the people whose doors were broken down on the basis of a form signed by another agent. The Fourth Amendment argument Blumenthal built in that room is now in the congressional record, attached to specific cases, specific names, and a specific memo that was never publicly announced. What comes next matters. Whether the 22 documented cases produce civil litigation, whether the memo's policy is challenged in federal court, and whether U.S. v. Lucas holds under Supreme Court scrutiny, whether the director's prior statement, no U.S. citizen is subject to immigration enforcement, becomes a factor in those proceedings. The Constitution does not have an ICE exception. The Fourth Amendment does not ask which agency is doing the searching. It asks whether a judge said yes. No judge said yes.